Hi, everyone. This is attorney Rob Wells here with you from the law office of Robert M. Wells. Our office specializes in landlord and tenant issues. In this video, I'm going to talk about if you can help a loved one, such as your parent or even a friend, with their eviction. Now, this has come up a lot, and it came up the other day for me, and it came up about a week and a half ago. The scenario is this. A family member is trying to help out a parent with managing their rentals, and then things go wrong, and then the child of the parent contacts my office and asks me, hey, I want to do an eviction. Can I do it? And we get into a conversation about the issues, and then I come to find out that the child who has come to me, or the friend, or you insert whatever relative or relationship you have with the individual, is not the owner of the property. And they ask, well, can't I do the eviction in my own name? I'm helping out my mother, or I'm helping out my friend, or I'm helping out, whoever. And my unfortunate answer is no. And the reason why you can't help someone which you don't have, you're not the owner of the property of, and an eviction action is the courts require what's called a real party and interest, meaning you're generally the owner of the property. Now, for my property managers out there, don't panic. You're okay. Generally, an owner can delegate these items, but it has to be done in a certain way. For example, professional managers like licensed real estate brokers and salespersons can act on an owner's behalf as long as they have a written property management agreement. That would be acceptable. What about a child or a relative or friend that has a power of attorney over the owner? The owner's granted them a power of attorney. Yes, we could possibly help you out. Now, there are some cases where, the real owner, the property owner, may be available, but they may be elderly, and it may not be convenient for them to go to court. And I got this question the other day about, well, since I have a power of an attorney, can't I just act on the owner's behalf? And, the power of attorney has the requisite terms and so forth. And I tell them, yeah, you can help them out and we can do the action under your name. But in some cases, that's not preferable, particularly with certain just cause or no fault just cause evictions. For example, an owner that wants to go out of the rental business or remove their unit off the rental market is a prime example. The number one thing that's going to be asked, or the court's going to wonder if your case ends up in court, is does the owner have a genuine interest? And in that scenario, for example, it would not be advantageous to have a power of attorney come to court with me to state the owner's actual intent of removing a unit off the rental market, especially if the owner is able to go to court and able to be listed as a plaintiff in the action. I, for example, wouldn't even consider a power of attorney agent if the owner's available in that case, because we want to hear from the owner if their intent is called into question. So sometimes some of these answers are, yes, technically you could do something, but should you do something? It all depends. And each one of these cases nowadays particularly needs to be evaluated on a case-by-case basis by seasoned counsel. Listen, if you're going through one of these situations where you have a bad situation with a tenant, or you have a problematic issue, a landlord-tenant issue, and you need someone to review your case, please let us know. We'll be happy to take a look at your scenario, because every case is going to be a little bit different. And just because you can do something doesn't mean that you should. So if you're in a situation where you're dealing with you are considering terminating a tenancy, or you need advice about how to go about your landlord scenario, please let us know. Our information is down below. And until next time, we'll see you then. Thanks.